Good evening. Welcome to Philosophy of Law. We want to look at the dilemma when the law says one thing and justice says another. What should happen in that case? This is another philosophical challenging ideas that I think everyone should know. Imagine this. A wealthy grandfather writes a will, leaving his estate to his grandson. The law is very clear. The will is valid. The grandson is the rightful heir. But before the grandfather dies, the grandson murders him to get the inheritance sooner. Now the judge faces a difficult question. The law says the grandson should inherit. Justice says he should not. What should the court do? This is not a thought experiment as usual in philosophy. It's a real case. And it forces us into one of the deepest questions in legal philosophy. What to do when the law and justice seem to point to different directions. Most law students spend years studying statutes, precedents, constitutions, procedures. But beneath all that lies deeper philosophical question. What makes a law a law? Is law simply because it was enacted properly? Or must law satisfy some moral standards before it deserves obedience? Understanding legal philosophy sharpens one's advocacy, improves statutory interpretation, and helps lawyers navigate ethical gray zones where black letters law provides are not easy to answer. For centuries, legal philosophers have divided into two major groups. The first camp says law and morality are separate. The second group says law and morality cannot be completely separated. Legal positivists, such as John Austin and H.L.A. Hart, argued that law is law because the law system says it's a law. Whether a law is moral is a different question. In this case, a cruel law can still be a valid law. A foolish law can still be a valid law. An unjust law can still be a valid law. For positivists, the lawyer's first task is to determine what law actually says, not what it ought to say. This approach gives predictability. It respects the separations of power between the governance, and it gives clarity for judges. In Kenya, if one was to try and look around who is a legal positivist, one might settle for Professor Githu Muigai, former Attorney General. Throughout his public career, the Attorney General has often emphasized fidelity to the Constitution, constitutional text, statutory provisions, and institutional procedures. Even where political or moral arguments were compelling, his legal reasoning frequently began with a straightforward question: what does the Constitution or the statute actually provide? While no lawyer fits perfectly into a single philosophical category, the former Attorney General would be cited as a Kenyan example of a lawyer whose approach to law reflects positivist instincts. But another tradition strongly disagrees with the legal positivists. Thinkers like Thomas Aquinas and later Lon Fuller argued that law must contain a moral core, a system of rules that's fundamental and just loses part of its claim to be legal or to have legal legitimacy. Fuller spoke of an inner morality of law. He argued that laws should be clear, public, consistent, prospective, and capable of guiding human conduct. For natural law thinkers, legality without justice is never entirely sufficient. So, in this category of thinkers from Kenya, we could pick out former Chief Justice William Mutunga. Mutunga consistently emphasized that the Constitution is not merely a technical legal document. He argued that it embodies values, human dignity, social justice, equality, and transformative constitutionalism. His jurisprudence often reflects the belief that the law derives legitimacy not only from formal enactment, but also from the commitment to justice and constitutional values. That places him closer to natural law and transformative constitutional traditions than he is a positivist. Now, return to our grandson's story who murdered his grandfather. The statute seemed very clear. The will appeared valid. The court ruled against the grandson. Why? Because the judges argued no one should profit from his own wrongdoing. Notice what happens there. The judges did not simply read the words. They appealed to principles of justice behind the law. That is legal philosophy in action. Then another group arrives on the scene that challenges both sides, the legal positivists and the natural law. And these are the legal realism. Thinkers like Oliver Wendell Holmes Jr. and Jerome Frank argued something uncomfortable. They argued that maybe law is not primarily what statutes say. They think that maybe law is what the judges actually do in court. Holmes famously wrote that the life of the law has not always been logic. It has been the experience. In this sense, realists observed that judges are human beings, and in their everyday work in court, they bring assumptions, policy concerns, personal experience, and practical realities into legal decision making. And if you want to predict the outcomes or understanding of human behavior, may be as important as understanding the legal doctrine. So in legal realism in Kenya, one of the scholars that we could cite is Justice Mohammed Ibrahim. His judgments often display sensitivity to practical realities, social consequences, and institutional context. Rather than treating legal disputes as purely abstract exercise, this particular judge considers how legal rules operate in the real world. That type of pragmatic orientation resembles the concerns of legal realism. Some later thinkers pushed even further away from legal realism, legal positivism, and natural law. And these are critical legal scholars and feminist legal theorists and race theorists who ask the question, who benefits from legal rules? Who bears the cost? Whose interests are being protected in legal procedures. They argued that law sometimes represents, or rather presents itself as neutral, while reflecting the existing power structures. Whether one agrees with this perspective of the critical legal scholars or not, lawyers do encounter constantly in modern constitutional litigation, or do have this kind of position in modern legal constitutional litigation, human rights disputes, and public policy debates. One of the scholars that you could cite as a critical legal scholar would be Professor Makau Mutua. His scholarship frequently examines law through the lenses of power, colonial history, human rights, and institutional inequality. Rather than assuming that legal rules are neutral, he often asks who benefits, who is marginalized, what structures of power are being reinforced. These questions closely resemble the concerns of critical legal studies. The other person that we could look at from this perspective and maybe add the feminist angle to is Martha Karua. Throughout her legal and political career, she has consistently advocated for gender equality, women's rights, and reforms addressing structural discrimination. Her work reflects feminist legal insights that legal system must be examined for the ways they affect men and women differently. The most effective lawyers often move between all the three perspectives. When drafting contracts, one would be possibly a positivist because they want the text to matter. They have to be precise. The rules matter. But when predicting the judges, they must think like a realist. They must put into consideration the human behavior, institutional context. When arguing constitutional principles, human rights, or legal reform, they often think of the natural law theory, justice issues, what is the purpose of the matter in court, and what are the moral principles at play. Today, artificial intelligence AI can review contracts, summarize cases, and even draft legal documents. But suppose an AI could perfectly apply the statute. Would that eliminate the need for legal philosophy? Since legal philosophy seems to be based on human intuition, it seems that's not the case, because the hardest legal questions are rarely about applying the rules. They're about deciding what fairness requires when rules collide, conflict, or fail. In that sense, every legal system focuses faces the permanent tension when the law seeks order, justice seeks fairness, and sometimes they align beautiful, and sometimes they pull in opposite direction. And when they do, judges, lawyers, and citizens must decide which vision should prevail. The philosophy of law will not win your next motion in court, but it will help you to see arguments others miss. It will help you understand why courts disagree, and it will also help you to navigate the space between legality and justice. And if you look closely, Kenya's legal history, you will find judges, advocates, and scholars embodying each of these traditions. Some emphasize rules, others emphasize justice, Others focus on power, context, and social consequences. And the debates of legal philosophy are not confined just to textbook. They play out every day in Kenyan courts. The deepest legal question is not what does the law say? It is when the law and justice disagree, which one should carry the day? I hope you've learned something about law and how law plays out in society, in courts, and what lawyers and advocates and judges do. This was another of my video of philosophical challenging ideas that I think everyone should know.